Good afternoon, everyone. I'm Susan Bryson. I teach in the philosophy department, and it's my enormous pleasure to welcome you to Professor Anita Allen's Timbers Lecture this afternoon on privacy law and racial justice. It's being held in conjunction with a new philosophy course I'm teaching at Dartmouth this summer on ethics and information technology. The Timbers Lecture is an annual endowed lecture that was established in 1995 in memory of the Honorable William H. Timbers, class of '37, who was a judge on the U.S. Court of Appeals for the Second Circuit from 1971 to 1981. And I see some of you here were in this room 3 months ago to hear another Dartmouth alum, the Honorable Beth Robinson, class of '86, who was also appointed to the U.S. Court of Appeals for the Second Circuit. She was appointed just last November, the first out lesbian to serve on a federal circuit court, and was sworn in a little over a month ago. So change is clearly in the air, especially with the appointment of Sian Beilock just a week and a half ago as the first ever woman president of Dartmouth in its over 250-year history. I want to thank the Nelson A. Rockefeller Center for Public Policy and the Social Sciences, the Leslie Center for the Humanities, the Newcomb Institute, the Wright Center for the Study of Computation and Just Communities for making this lecture possible. And I want to convey special thanks to Joanne Blay in the back there, whose extraordinary administrative work as program officer at the Rockefeller Center made this event actual. This lecture is being, yes, thank you. I want to applaud her. Thank you. This lecture is being live streamed, and those of you watching online will have a chance to ask Professor Allen questions during the half hour or so of Q&A after the lecture. You can ask questions by emailing rockyqa@dartmouth.edu. And those of you who are here in person, please wait for one of us to pass you a mic so that those who are online and those who later watch a recorded version will be able to hear your questions. I'm absolutely thrilled to introduce today's speaker, Professor Anita Allen, who is a Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania. A graduate of Harvard Law with a PhD in philosophy from the University of Michigan, Professor Allen is internationally renowned as an expert on the philosophical dimensions of privacy and data protection law, bioethics, legal philosophy, women's rights, and diversity in higher education. Professor Allen is an elected member of the National Academy of Medicine, the American Law Institute, the American Philosophical Society, and a fellow of the American Academy of Arts and Sciences. In 2018-19, she served as president of the Eastern Division of the American Philosophical Association. She was awarded the 2021 Quinn Prize for service to philosophy and philosophers by the APA, the 2022 Founders Award by the Hastings Center for service to bioethics, and the 2022 Privacy Award of the Berkeley Law and Technology Center for groundbreaking contributions to privacy and data protection law. A prolific scholar, she's published over 120 articles and chapters, and her books include Unpopular Privacy, What We Must Hide, Privacy Law and Society, The New Ethics, a guided tour of the 21st century moral landscape, Why Privacy Isn't Everything, Feminist Reflections on Personal Accountability, and Uneasy Access, Privacy of Women in a Free Society. She's not only a consummate scholar, she's also an extremely influential public intellectual who appears frequently on television, radio, and other major media, and has given lectures all over the world. It's our great good fortune that she's here today at Dartmouth to give the 2022 Timbers Lecture on privacy and racial justice. Please join me in giving the warmest of welcomes to Professor Anita Allen.
Thank you very much. I'd like to once again thank the the Nelson Rockefeller Center and the Leslie Center for the Humanities and all the other great people and organizations that Professor Bryson mentioned for my being here today. And I want to thank especially Professor Bryson, who for many years has been one of my most, I would say, one of my most consistent advocates in the profession. And I really appreciate all the ways in which my career has been enhanced by your input. I also want to acknowledge those Native Americans on whose traditional lands we today sit. So this lecture today is a postponement. I was actually originally supposed to give the Timbers lecture in the year, I think, 2020, and then COVID, and then 2021, and then still COVID, and now this year. And we are fortunate enough to be able to meet many of us in person, and I'm very grateful that finally I'm able to give this lecture. But the talk that I'm going to give today is by no means the talk that I would have given had I been able to speak to you in the year 2020, because the context has radically changed. So how has the context changed? Well, for one thing, the pandemic has changed the context, obviously. But in addition to that, the context has been changed by the racial reconciliation and the racial protests, Black Lives Matter protests of the summer of 2020, which put our nation in a different place vis-a-vis African Americans and issues around justice, and including those around Fourth Amendment privacy concerns and policing. But then the final way in which the context is different is that we are now post Dobbs versus Jackson. We've now had the overturning of Roe versus Wade. And so we have a whole different jurisprudence, law of reproductive privacy, inequality to think about. So it would be, I think, remiss of me to ignore the Dobbs decision, given that I'm a scholar of women and privacy. And it would be obviously remiss of me to ignore issues of African American racial justice in light of what happened 2 summers ago. And so what I'm going to be doing today is to try to talk to you about some of the perspectives that I have developed as a scholar and a teacher since 2020. Because I like to think that I grow as the society pushes me, and that new context means that we don't do things in the old ways. It's striking to me how for 30 years of being a privacy scholar, I rarely focused specifically on African American issues in relationship to privacy. I had written a whole book on women's privacy, and I had done work on gender and abortion rights, but I had really never focused on African Americans and privacy. And I've been trying in the last 2 years to make up for that. So you'll see some of that today in my remarks. So some of the most recent works of mine that reflect my current thinking about racial justice and privacy include an article that I published in the Yale Law Journal Forum, which I would love for you to read sometime. It's called Dismantling the Black Opticon. And in that piece, I describe the ways in which the digital economy and digital life are particularly difficult for African Americans. And I describe 3 different sets of vulnerabilities that I believe African Americans have in the digital age and the digital economy. One, I describe the panoptic difficulty of over-surveillance. Secondly, I describe it, what I call, borrowing a phrase from a European scholar, a banoptic dimension where African Americans are particularly susceptible to being excluded from opportunities that exist for other groups online. And then finally, I describe what I call the conoptic predicament, which is the ways in which scams and con jobs and discrimination happen for African Americans, as well as for Hispanics, by the way, and Native Americans and some Asian groups as well. But this black opticon of over-surveillance, exclusion, and predation are described in detail in that article. Another, though, thing that I've done since 2020, when the world changed for me and for all of us, I guess, I published actually it's a forthcoming article in the Oxford Handbook of Applied Philosophy of Language, and it's about the deeply and thoroughly political and politicized character of privacy discourse in the United States. That piece, I think it'll be out in a couple of months, but it's my exploration of the ways in which privacy exists in our language, in our discourse, as a kind of what W.B. Ghali would once called an essentially contested concept, one that is, by its very nature, not amenable to easy definition or agreement. And so I explore that theme in that work. And then finally, I'm working with a group of 3 other African American scholars on a new textbook that's going to be, I think we're toying with the name Privacy, Racial Justice, and Society, but a textbook that explores from an African American lens the whole history of privacy law going back to the late 18th century through the present time. So those are some projects I'm working on that I think reflect this new perspective, a taste of which you'll get today. 4 key points, I think, I've been led to, and I want to share with you. One is that I've already mentioned that privacy discourse is thoroughly political and politicized. Second, that philosophers, I know there are some philosophers in the room, I'm going to pick on you a little bit, but philosophers have sometimes been more part of the problem than a solution, because philosophers have often advocated very technical, esoteric definitions of privacy that purport to prescribe to all of us how we ought to use the language of privacy, whether we use it that way or not. And I've come to believe that this has played into the hands of non-progressive elements in our society, making it harder for women and people of color to achieve justice by obscuring what's really at stake. And I'm now an advocate of what I call critical definitional facilitation rather than prescriptive analytic definition. And my approach says, instead of telling people what privacy doesn't mean and how they can't use that language to talk about facial recognition or abortion, instead, let's figure out what people are trying to say. Let's listen to what people are trying to communicate by way of valid concerns using the language of privacy and focus on fixing that. Fix the underlying problems, not on telling people how to use their own language. Third point, I think we need to just completely retell the history of privacy law. I mentioned in this textbook we're starting with the late 18th century. You mean there was privacy law in the late 18th century? Well, the Constitution happened in the late 18th century, so yeah, there was. But you get a very interesting perspective on privacy and the law if you don't start with the 20th century. So a place I would want to start after, of course, the Constitution, which was famously inclusive of the Fourth Amendment and the Fifth Amendment and the First Amendment, which had been subsequently held to protect privacy interests. But in the 1820s in North Carolina, there was this very interesting use of privacy discourse in the law where, here's what happened. So an enslaved woman named Lydia was trying to run away from this man who had hired her out from her owner. And he didn't want her to get away, so he shot her. And she was severely wounded. Well, it was sufficiently outrageous to have shot her for a minor problem that the white people of North Carolina in his community said, we have to prosecute this guy for battery, and they did, and he was found guilty. But this man didn't like the fact that he was found guilty of battery for shooting an enslaved person, so he appealed the conviction. The case went to the Supreme Court of North Carolina, and Justice Ruffin, who was himself a slaveholder, found that, well, actually, we shouldn't be punishing people for wounding slaves because it interferes with the privacy of the master-servant relationship. The master slave relationship, for the government to be telling people whether or not they can chastise, correct, even wound their enslaved people. And then 20 years later, same state, a white woman, you probably know this case, State versus Rhodes, a white woman brought a criminal action against her husband for beating her. And the husband, was found guilty, but then he appealed his decision, his criminal conviction. And once again, the Supreme Court of North Carolina, this time citing the slavery case, said, oh, it would interfere with the privacy of the family for the courts to allow a husband to be punished for beating his wife. And after all, the wounding, the stick was only, yay big, the size of a man's thumb. That wasn't that bad, right? So for me, among the earliest examples of the use of privacy discourse in American law actually is discourse which I wouldn't applaud. You probably, I hope you wouldn't applaud it either. Privacy discourse being used to solidify the grip that men have over women, that owners have over enslaved people. That's how privacy was interpreted early in our American history. Not as a lovely, beautiful, warm, and fuzzy right to protect us against the effronteries of the press overstepping its boundaries and reporting on our private lives. We the rich people, who can worry about the media being excessively interested in our private lives. That wasn't the way the discourse of privacy was first manifested in American case law. Instead, it was there in terms of this upholding of male hegemony and slavery. So we need to retell privacy law through the lens of race to capture that. But also, I can tell a very interesting story about the ways in which the experiences of African Americans have been pivotal in the advancement of privacy rights in the United States. So if you do go, let's start with just the 20th century, for example, 1950s NAACP versus Alabama, that case brought by black people established a constitutional right to associational privacy. That was the NAACP and great lawyers, included Thurgood Marshall and his associates, bringing a case to the Supreme Court that led to all of us having a right of associational privacy, a right not to be forced to hand over our membership list if we're in an organization to the government, just to start that conversation. Mapp versus Ohio. Dollree Mapp was a black woman, and her brave appeal to the Supreme Court led to the exclusionary rule. Why is it that if the government takes information that they acquire in violation of your Fourth Amendment rights, they can't use that in a criminal prosecution? It's because Dollree Mapp had the courage to press her appeal to get the Supreme Court to conclude that, yeah, you can't allow the government to benefit from wrongdoing, so we have to have an exclusionary rule. Loving versus Virginia, a black and Native American woman, right, Mrs. Loving, brought that case to the Supreme Court, right, to insist that she and her husband had a right to get married and to have their marriage respected in Virginia, which had laws against interracial marriage. And I could go on and on and on because I would even venture to say, I think I have some data to back this up, that most of the important Fourth Amendment and Fifth Amendment cases in the last 20 years that have advanced all of our civil rights in the area of criminal procedure have been brought by black people or Hispanic people. So we have a huge role to play as victims and as legal activists and lawyers and judges. Thurgood Marshall, I mentioned him earlier, but Thurgood Marshall was the judge who wrote the opinion in Stanley versus Georgia, which found that people have a right to view pornography and obscenity in their own home, not child pornography, but regular pornography, in their own homes without being criminally prosecuted. That was Thurgood Marshall's opinion. So we have this interesting history of being sort of abused by privacy discourse in the beginning of our country, to then in the 20th century, black people joining others to push and advance the idea of constitutional privacy, right, using their experiences and their expertise to make that happen. Two of the most important recent CEOs of Planned Parenthood, by the way, have been black women. Faye Waddington back in the early 1990s and Ms. Johnson today. Okay, so all that background. Privacy law is in a state of disarray. And I'm talking about three different kinds of privacy law. Informational privacy law, I would argue, is in a state of disarray, along with physical privacy law, laws protecting seclusion, solitude, geolocation, disarray, and decisional privacy represented by the Dobbs case is in a state of disarray. Let me just develop those points with you for the duration of my time with you this afternoon. So informational privacy law is a very important part of privacy law. It's the laws, whether they're common laws or constitutional provisions or statutory provisions, that protect our interest in confidentiality, anonymity, data protection, related cybersecurity, all that good stuff, all right? And the law that does that in the context of the current digital age, I believe, is in a state of disarray. And the disarray that exists there is the fact that not only do we not have a single federal statute or law that kind of ties it all together and guarantees us basic protection of life as consumers, life on online platforms, but on the state level, we now have an emergence of individual state consumer privacy laws being enacted that are inconsistent, so that the business sector and people like you and me don't know what the heck's going on. We don't know what the rules of the game are anymore, because we lack a central national policy in this area. I mentioned that physical privacies include seclusion, solitude, freedom from unwanted surveillance, freedom from watching, monitoring, tracking, tracing, geolocation. This kind of privacy is closely related in the digital age to informational privacy, of course, because so much of what might start as physical privacy, namely a camera being pointed at me while I'm standing in this room, it turns into informational privacy through digital technology. So there's a close relationship between what I would call informational and physical privacies in the digital age. So the fact that we don't have good laws protecting informational privacy also means that we don't have good laws protecting physical privacies. Now, one of the interesting things happening today about the way we think about the right to privacy is that privacy is being seen as a civil right. So the fact that we don't have a strong federal, coordinating federal statute or consistent state laws impacts what many experts are now being called privacy as a civil right. What does it mean to say privacy is a civil right? Well, to remind you, privacy has been a common law right, meaning a judge-made right in the United States since 1906, when the Georgia Supreme Court became the first state Supreme Court to recognize the existence of a common law right to privacy, namely a right that judges could appeal to resolve conflicts in private lawsuits before them. And then after World War II, in 1948-ish, privacy came to be thought of as an international human right, something that all just governments and just regimes ought to respect, the privacy of correspondence and family life, for example, being part of this human right to privacy. And then in the 1950s and 60s in the United States, privacy became a constitutional right grounded in the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, the whole penumbra of the Bill of Rights, and then ultimately in the 14th Amendment by virtue of constitutional holdings by our Supreme Court. But the idea that it's also a civil right is something like very, very recent, and just in the last couple of years, have experts begun talking about privacy as a civil right. We're not used to thinking about privacy as a civil right. We're used to thinking about civil rights as things like voting rights, right, fair housing, integrated universities and public schools at all levels, public accommodations laws, right? Access to swimming pools and grocery stores and amusement parks. That is traditional civil rights law. So how does privacy kind of fit into the notion that it's a civil right? And there are lots of important lawyers out there making this argument. For example, the former NAACP Legal Defense Fund, now just Legal Defense Fund, the Legal Defense Fund is taking the position that privacy is a civil right, as are many minority-led organizations around the country. And even the Brookings Institute is saying, yeah, privacy is a civil right. Well, what does it mean? Well, unfortunately, we don't know yet what it means because we haven't had a good test of it. But here's one thing. Here's two things that some people think it means. Some people believe that just as a public swimming pool is a place of public accommodation, or a shopping mall is a place of public accommodation and must be available to all on the basis of equality, non-discrimination, so too is the internet. So too are digital platforms, Facebook, Uber, Amazon. They can't discriminate against us, excluding us from their services any more than the shopping mall down the street could, or the swimming pool could, or the amusement park could. And so this idea that we can kind of take, by analogy, physical world public accommodations law and apply it to the internet is something that's being experimented with now by various entities who are pursuing the protection of privacy interests through the law. Another angle on all of this is that there are folks arguing that digital platforms, the internet more broadly, are public utilities like the phone company or the light company, the electrical company. And just as you couldn't discriminate against people based on race, access to electricity or water, similarly, you shouldn't be able to discriminate against people based on their race when it comes to the use of the internet or a digital platform. Very controversial, very cutting edge. We don't know yet whether these theories, these newfangled theories, are going to work. It seems to me that as long as you acknowledge that we shouldn't be discriminating against people on the basis of their race, ethnicity, gender, sexual orientation, et cetera, it isn't all that important whether we can technically describe the right as a civil right versus a human right versus a, but I do think that it's not crazy, right, to try to win over people to understand the importance of privacy for individual lives and for group life and for democracy itself by analogizing it to more familiar civil rights. Okay. So, this uncertainty on the state level. Let's do the federal level first. This 117th Congress alone, 16 separate bills introduced into Congress having to do with privacy. Consumer privacy, health privacy, algorithmic justice privacy, this kind of privacy, that kind of privacy. Few of them have bipartisan support. Some of them have bipartisan support. Some are incredibly narrow, having to do just with COVID information. Others are incredibly broad, like Senator Kirsten Gillibrand's important bill proposing the creation of a federal data privacy agency that would have a civil rights division and a research division and a consumer complaint division, a whole agency to protect privacy. So from the very broadest to the very narrowest, none of them are going anywhere at the moment, right? There was a lot of chatter among my privacy advocacy friends about a month ago about, the new children's privacy bills that amend the education privacy law and that amend the children's online Privacy Protection Act to extend its protections to even older children. That's bipartisan support, that's gonna get through Congress. Well, time is ticking away. We're more than halfway through the year and we still don't have anything on President Biden's desk to sign, right? A few distractions, war in Ukraine, a few distractions. So in the meantime, there's no national law that addresses the problems of over-surveillance, exclusion, predation experienced by black people or by anybody for that matter, right? There's just nothing there. We do have, an amazing array, I should say, admit, of privacy laws already on the books. We have financial privacy laws, and we have HIPAA, and FERPA, and ECPA, the Electronic Communications Privacy Act. We have lots of privacy law, but guess what? Most of these laws were passed like in the 80s or the 70s, right, before the internet, some of them, and they just don't directly address the kind of things we've been experiencing in the United States and abroad, around the world in the last decade or so. So that's a problem. In the meantime, the business sector, big tech, is thinking, this works to our advantage, because they're not as regulated by federal law as perhaps they are in Europe. Not perhaps, as they are in Europe. Although the GDPR, the European data protection law, as amazing as it is, it doesn't really cover all the issues around algorithmic transparency and accountability that so many of us would like to see addressed by a new comprehensive regime in Europe and in the United States alike. So we have that problem. So there's a federal problem. On the state level, so now 5 states have enacted their own state consumer privacy laws. Okay, California was first, then Colorado, then Virginia, then Utah. I think Connecticut was the most recent one. That's 5 states. 6 more states, bringing us to 11, including my own home state of Pennsylvania, have pending or have had recently pending laws that would amend the situation and perhaps create some level of protection for all of us as we use online businesses and worry about data breaches and so forth. But most states, the other states, have nothing. But they're probably going to have something because the states tend to be copycats. So, so we have 5, 6 in the wings, and the rest probably going to come along. Imagine if you are an Amazon or a Google or some small, startup, and you want to be doing business in all 50 states. You've got 50 different sets of laws to worry about. So you need a bank of lawyers. Go to law school, guys. Lots of work. A bank of lawyers to tell you how you can lawfully proceed in the various states. Now, I chose to focus in my most recent scholarship on the Virginia consumer data protection law. And I thought, Virginia, perfect if you're interested in race, right? It's a former Confederate. Of all the states that have adopted privacy laws, it's the only one that was a former part of the Confederacy. It still has race issues, some serious ones. Getting better, but still has issues. And it turns out that in Virginia, people of color are the ones who sponsored this bill, who brought this bill forward and who got it passed. A black man named Clifford Hayes was the principal sponsor. He had a couple of, I think he had an Asian co-sponsor and a mixed race co-sponsor. It's a multiracial group of people. Well, if a multiracial group of people are designing a privacy law, it must be pretty good, right? 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 Have I heard of interest conversion theory? Right. So I was disappointed when I read the bill because the bill that got passed, the law that got passed, which goes into effect, by the way, in January of 2023, this law, it's very weak. It's very weak. It doesn't do much at all. It's a start. And the people who put it forward would say it's a start, but in order to get a law passed quickly, they had to compromise, and not upset the business community. So Big tech loves the Virginia statute because it's so deliciously weak. So for example, the California statute allows individuals who've been wronged to bring a lawsuit. But in Virginia, you can't bring a lawsuit. If you think you've been wronged, you have to rely upon the state attorney general to bring a lawsuit. And so the trial lawyers in Virginia, they have their own interests. No one's pure here, but they like to be able to bring lawsuits and make lots of money bringing lawsuits. But they point out that in a state like Virginia that doesn't have a great history of protecting minorities, what's to say that a particularly politically leaning one way or leaning the other way attorney general is going to protect the interests of all the citizens equally? So you may not get as much protection as you might like if you invest this right to sue only in the attorney general. Now, when I first learned about this, that people wouldn't have a private right of action, I wasn't too freaked out because after all, many of our privacy laws don't provide for a private right of action. So for example, HIPAA, right? Your doctor discloses your personal medical information to your next door neighbor whom you can't stand, and that person, does all kinds of evil things to you, exploits the knowledge of your medical problems and hurts you very badly. Well, guess what? You can't sue under HIPAA. Only the Department of Health and Human Services can sue under HIPAA. So you don't have a private right of action under HIPAA, which people back in the 1980s when HIPAA was passed said, this is a problem. But we've come to live with it. And originally there weren't too many great HIPAA actions. There have been plenty of pretty powerful HIPAA actions recently, and so the government's doing better. But still, there's no private right of action. FERPA, so all of you many of you are students, and you have transcripts, right? And even mom and dad can't look at your transcript without your permission. If you don't know that, you should. But there's no private right of action under FERPA. If Dartmouth violates your FERPA rights, gives your transcript to mom and dad without your permission, gives it to the local newspaper because you've been involved in some disciplinary action or whatever, somebody can bring an action, but not you. The government has the right to bring an action on behalf of you or against the school for having violated your FERPA rights. So we're used to the idea on the national level that there's no private right of action. But I must say I've come to be more concerned about the lack of a private right of action on the state level precisely because of the nature of state politics. And we've seen so much overreaching and politicization of rights by a state government. I'm worried that we may not have private rights of action in some of these states. Also, preemption is a big problem. So when you pass a state law, you have to worry about whether or not some higher law, federal law, preempts it. And so we don't quite know yet whether some court will someday find that some of these state law provisions are preempted by HIPAA or Gramm-Leach-Bliley financial privacy law or some other federal law. Now, the state lawmakers, one of the reasons why their laws are so weak is because they were trying to avoid any appearance or reality of conflict with federal law. So they say things like this statute does not purport to change any rights established under HIPAA or under. So they try to avoid the problem, but avoiding the problem also makes them pretty darn weak and maybe even a little bit intentionally so. So that's the disarray. The disarray is 50 different states. They can take 50 different approaches. There's no obligation whatsoever for one state's laws to be consistent with another. There may be some strategic reasons why states don't want to be so different from their colleagues or sister states, but there can be quite a bit of variation. We've already seen variation between Virginia, Colorado, California, et cetera. Few of the states have laws as strong as California's, which even has this sort of right to be forgotten that other states just simply don't have as of yet. So that's disarray there. Okay. On the decisional privacy front, what is the disarray? And this problem worried abortion scholars way back. This is not a new problem, a new concern, but it's new newly ripe because of the Dobbs decision. But remember Larry Tribe? He's this big retired Harvard constitutional scholar who was actually, I think, cited in the Dobbs opinion. But Larry Tribe has many times made the point that, from his point of view, it doesn't make sense, and it's not right, that women's reproductive freedom is contingent upon where they happen to live, where they happen to be going to school that year. You know, so I'm in New Hampshire, going to school here, then I want to go to law school in Texas. Guess what? I have totally different rights, abortion rights, in Texas than I had in New Hampshire. That seems to be treating reproductive rights in a frivolous way, to say, well, you know, it depends on where you are. If you're in Mississippi, you know, Michigan, but wherever it seems that something so as important as a right which protects your investment in your future, in your family's economic well-being, that kind of a right is contingent upon where you happen to live seems wrong. Seems wrong. And I guess that's the kind of disarray that's worrying me right now. The disarray of having 50 states and 50 different abortion regimes. So in some states, there may be, after this decision, no abortion right at all. In other states, well, depends on, well, maybe it's the life of the mother. Other states, well, maybe it's hardship, like in Europe. Oh, no, maybe if it's rape or incest. Viability, 4 weeks, 6 weeks, fetal heartbeat, whatever that seems to mean. Well, okay, some abortions, but not D&E, not dilation and extraction, not partial birth, not that kind of abortion. And on and on and on, where whether you can have an abortion or not, what kind of abortion and when will depend upon where you happen to be hanging your hat that year. And we're a very mobile society. We move for jobs, we move for school, we move for to be closer to our families. We move all the time, and it seems very, very wrong that a woman's and a family's entire future would hinge upon whether they happen to be in one locale or another. It could even be like you just move across the state line, like, you know, you're in New Hampshire, but you're sort of like, could also be in Vermont or Massachusetts or New York. We're too mobile and too adjacent a society to have such radically different regimes around abortion. Travel bans, tattletale rules, insurance limitations, all of these differences just make for chaos. And so imagine you're being a parent trying to explain to your 12-year-old what their abortion rights are. It's like, well, I mean, as long as we keep living here, but if we move over there, I can tell you a totally different. Come back tomorrow for what happens if we accept that job in Kentucky, because there'll be a totally different story over there, right? So that's disarray. That's randomness and arbitrariness. But of course, you know, we're not just worried about the implications of Dobbs by virtue of the state law conflicts. We're also worried about the harm, right? The harm that a United States without a firm foundation of abortion freedom represents. So we know that maternal mortality rates are, for some reason, rising. You think, well, we become more sophisticated, medical science advances. Shouldn't maternal mortality rates be decreasing? Shouldn't there be fewer women dying after a live birth? But guess what? It's the opposite's happening. The rate was 17 women dying per 100,000 in 2018 to 20 dying per 100,000 in 2019 to 23, almost 24 dying per 100,000 in 2020. Abortion, the right to decide to end a pregnancy can be a life-saving measure for some women. Why are our infant mortality rates are also rising? A different story. Let's focus today on the maternal mortality. But why are they rising? Some say because pregnant women are older. You know, the idea that a pregnant woman who might want to get an abortion is like, 18 or 17, that's not the story so much today. It could be she's like 40, or 37, not a teenager at all. Older women, that's associated with more maternal mortality. More heart disease among women getting abortions and more heart disease among women who might be eligible for an abortion but for this decision. More diabetes, more hypertension, more obesity, more C-sections. All of these are thought to be possible ways of explaining why more women are doing more poorly with their pregnancies. We're not as healthy as we should be, right? We're overweight, we're hypertensive, we have diabetes. I have many of these problems myself. I understand them. They're hard to fight, but they're problems, and they're contributing to maternal mortality, and we may need to have an abortion right as a way to protect women and their families from the risk of this kind of adverse outcome, as well as the adverse outcome of infant mortality. Who is most likely to die from giving birth or pregnancy? Well, Black women, followed by Native American women, followed by Hispanic women, followed by white women, and then Asian women at the bottom of that continuum. The need for the abortion right is in part there because we don't have great access to contraception in the United States, even still. A lot of women, believe it or not, you in this room are probably exceptions in that respect. Birth control is expensive. It costs about $231 out of pocket for sterilization. And by the way, 18% of women seeking some kind of birth control choose sterilization, which is a radical move, right? Implants, $433 a year. IUDs, $200 a pop. Depo-Provera shots, $245. NovaRing, $2,000. The pill, $268 a year. So if you are a woman on low income or even no job at all, you're on some public assistance, it is darn hard to afford birth control. And if some states have their way and they start to stand in the way of insurance companies insuring birth control and or abortion, we're in big trouble. And by the way, among the most scary problems of all that the Dobbs decision raises is that the line between birth control and abortion is not so clear-cut, right? Some people think that any kind of contraception which operates on a fertilized egg is an abortion. And most birth control does not prevent fertilization, it prevents pregnancy. It prevents the implantation of a fertilized egg and the start of the pregnancy in that way. So we have some real problems here. But there's always adoption. So why? Adoption is not simple, right? How many people in America would be reaching their arms out to adopt a Black boy? So, headline, New York Times, Black adoption is cheap. Cheapest to adopt Black boys because they're not seen as desirable. More than almost half of the babies that are adopted are white babies. I think 49% is the number that I've seen. 16% are Black, 2% are Native, 10% Asian, fewer than that Hispanic. But it is very, very difficult to place a Black child for adoption. Easier for white kids, easier for, in some cases, for mixed race kids, but hard for Black children. People don't want dark-skinned babies, it turns out. Now, I actually have firsthand experience with this because I have myself attempted to adopt and successfully adopted two children of color. And I can tell you that whereas my friends at work who were trying to adopt babies from China and Russia, they're like, we've already spent like $30,000, $40,000, $50,000. I'm like, I didn't spend any money on my adoption. I just went down there, filled out the application, and a month later I had a baby. Right? It was like easy breezy. I mean, I'm being silly, but it was almost kind of like that, where it turns out that if you go to an adoption agency and you are a person of color and you say you want to adopt a child of color, it is not prohibitively expensive, and it is not prohibitively time-consuming, or it's not going to take you years to do it. It can be done relatively efficiently. I think that my daughter was adopted. We applied in January, had a baby in May. With my son, we activated the application, I think, in June, and had a baby in September. So, but this is not the story for typical adoptions, and I think that the notion you can just leave your baby in the fire station, or place it for adoption, it just completely ignores the racism and the racial dynamics of adoption. This is a little bit old story, but when I was pursuing adoption back in the 1990s, one of the agencies said to me, well, I just want to warn you that some families want to give the baby back when the baby starts to turn dark. So some families will adopt kids from India or black kids from the South, but then when the children start to turn really look like me, they look like, oh, we didn't think we were going to have a black child. So colorism is a huge problem in the adoption world. People want matchy-matchy. People want children who look like them. And I don't necessarily blame people for wanting children who look like them, but it does mean that we can't ignore this when it comes to thinking about how we understand the options that families have when they have an unwanted pregnancy to deal with. Okay, a couple more quick points, and then we'll stop and have some time for some conversation. So my main point for you today was that the law of privacy, the law that impacts digital life, and the law that impacts abortion is in disarray, and some of what we're left with is actually harmful to us. It's harmful that we don't have better digital privacy laws. It's harmful that we don't have better abortion laws. It's harmful that we don't have a national, federal, comprehensive set of privacy laws. It's harmful that we don't have a national, comprehensive set of abortion laws. And not only is it harmful, it's also it's hard to justify and explain, right? So I'm eager to get back in the classroom next month because I want my students to ask me, Professor Allen, what exactly was wrong with Roe versus Wade? I mean, what exactly was wrong with Roe versus Wade? Like, why? I've read Justice Clarence Thomas's opinion, and I read Alito's majority opinion. I'm still not sure I understand exactly what was wrong with Roe versus Wade. And why exactly don't we have digital privacy laws? Like, is it the lobbying of big tech? Is it just differences in? Is it just fortuity of too many other important things going on in the world for Congress to focus on data protection? What is the reason why? What is the reason why? And I don't have a good story about why we don't have digital privacy laws, except that it is the case that to some extent we have a tradition in the United States of laissez-faire, capitalism, and now we have on top of that, what Shoshana Zuboff calls surveillance capitalism and racial capitalism, Nancy Leong and others have described. And these various phenomena may well be reasons why, or part of the story why we don't have better internet digital privacy laws. But I must say I'm particularly confounded by the fact that we don't have better abortion laws, in part because I just don't understand why the current Supreme Court finds the jurisprudence of Roe versus Wade so defective and so intractable. Let me just point to a couple things that were said in the Alito opinion and that Justice Clarence Thomas signed on to. Under the jurisprudence of Roe versus Wade and Planned Parenthood versus Casey, that 1992 Pennsylvania case that went to the Supreme Court that modified Roe but upheld the essential holding of Roe, right? We used to think about the right to abortion as a fundamental right, meaning that the states could only interfere with the exercise of that right if they had compelling reasons to do so. But what our current Supreme Court has done is they've pulled the rug out from underneath us when it comes to conceptualizing abortion as a fundamental right. So Justice Alito, for example, and Justice Thomas both believe that it is ridiculous to think about abortion as a fundamental right. It's ridiculous because it's neither of two things that a right must be in order to be fundamental. According to traditional Supreme Court jurisprudence, in order for a right to be fundamental, it has to be either part of our nation's history and traditions or implicit in the concept of ordered liberty. One or the other. And they say abortion is neither. It's ridiculous, they say, to think that abortion rights are part of our nation's history and tradition. Look at the law. Go back. You can find statutes going back 100 years, 150 years that treat abortion as a criminal or illegal act. And part of our nation's history and tradition? No. Part of the concept of ordered liberty, the kind of liberty that we would all say we must have in order to be seen as a just society? No. And they point to countries like some of the European countries only recently got abortion rights. Ireland wasn't a country in which there was ordered liberty until they changed their abortion law. That can't be right. But what's so striking about this is they're pretending as if somehow we can't have a legitimate disagreement, right, about whether or not part of our nation's history and traditions include abortion rights, or whether ordered liberty, the kind of liberty that you must have to be a citizen of a just democratic society, that includes abortion rights. Where people like me have been arguing for 30, 40 years that abortion rights are both part of our nation's history and tradition and part of the concept of ordered liberty. History and traditions. Well, it wasn't really until the late 19th century that states began to make laws that criminalized abortion. And those laws were made, the Comstock era, the Comstock laws. These were, you might even say, Johnny-come-lately laws for the most part. They were not always part of the American story. And we can debate about whether the quickening statutes and all these kinds of concepts were meant that there was or there wasn't an abortion right. But there's definitely a conversation and a debate to be had. It's not ridiculous to say that abortion rights are part of our nation's history and traditions in the sense that it was left to families and to women early in American history to decide about pregnancy and childbirth. These were common law sort of expectations that it wasn't up to the state of Massachusetts or Vermont to decide whether you carried a pregnancy to term. It's about you and your midwife and your mother and your doctor and you yourself. It wasn't about the whole community weighing in on whether your life should include a baby or not. And then the idea that citizenship, that equal citizenship, that liberty, capital L liberty, exists in a world in which women don't have any control over whether or not they give birth, even if what they want to do is to have an abortion in the earliest weeks and months of pregnancy, that kind of citizenship is what we want to deliver to women, and that's it. That to me is, again, it's an arguable point. It's not ridiculous. So the good thing about Roe versus Wade, in my view, is that Roe versus Wade was a great compromise. It allowed the people who believe that abortion is morally offensive or religiously offensive or harmful to the unborn to make choices consistent with that decision. And it allowed people who take a different point of view, who believe in women having control over their own bodies, who believe that gender equality is dependent upon having choices about the timing of your pregnancies, et cetera. Everybody can live in accordance with their values. What they can't do is dictate how the other people should live. But in that sense, Roe was a compromise. Whereas Roe is often presented as an extreme that gives abortion on demand to irreligious, selfish, and cruel doctors and women. And that's just not the way I think it ought to be understood at all. So, again, had I come to talk to you in 2020, I probably would have given you a nice, straightforward lecture about digital privacy, talking about the information age, talking about the challenges of fair information practices, notice and consent conceptions of privacy in the business world, maybe a little bit of algorithmic justice tossed in, you know, a little bit of, but I wouldn't have been talking about race, and I wouldn't have been talking in such a passionate way about abortion, to be sure. In fact, I thought I was done talking about abortion. Right? That was Anita of the 1990s, but no, it's come back, and I think I feel just as strongly now about it as I did back then. My daughter, who is 26 years old, and I'll end here, very disappointed in her mother. Like, Mom, you need to be, why aren't you tweeting this? Why aren't you on Instagram? Why aren't you out there in the world sharing your perspectives on abortion with the world? And I say, well, but I've already done that, daughter. You know, here's all these articles I wrote. People can read them. The same arguments I made 20 years ago I'd make now, except that now it's more urgent because more harm is being caused by these chaotic. But I think you know, she made me feel maybe I should talk about this. Maybe I should not view that. Well, you know, now that I'm 70, let the 40-year-old law professors be the ones out there getting yelled at and screamed at. And why should it have to be me? But I think we all right now have a stake in whether or not our online digital privacy is going to be protected into the next decades, and whether or not our reproductive freedoms are going to be protected into the next decade. So I leave you there and look forward to our conversation. Thank you.
Thank you so much. For those who are watching online, Rocky Q&A at dartmouth.edu is the email address to send your questions to. And we'll just start right in with questions from the in-person audience, if anyone would like to raise a hand and wait for a mic. There's one mic over there, and I'll be passing this one around.
Hi. So as I was listening to your lecture, it seemed that we have a lot of different strands of thoughts about abortion. I mean, not abortion, but privacy going on. And each of those strands responds to very different needs as a result of the evolving social context and situation. I guess my question is that what might be the advantage and or disadvantage of uniting all those different strands of thoughts under the single concept of privacy? Is it advantageous that we be able to appeal to some shared common traditions of how to think about privacy, so it can allow us to address certain urgent problems? Or is it disadvantageous in other ways, because that may give our opponents ways of appealing to traditions that may hamper our theoretical goals? I wonder what your thoughts are on these. Thank you.
Thank you. So in my work, I distinguish between like 6 different strands or types, you might say, of privacy, right? Informational, physical, decisional, which I talked a little bit about today. But there are some that I didn't mention at all. I think I mentioned associational in passing in connection with the First Amendment and the NAACP versus Alabama case. But there's also what you might call proprietary privacy, like the privacies of the attributes of personal identity, like our name, our likeness, our voice. And then there's also intellectual privacy, like the privacy of our thinking, of our thoughts, of what we read, what we believe. And so the way I developed this list, it wasn't by sitting in an armchair thinking, okay, here are some things we might mean by privacy. And instead, I just read and read and read and read what we, in fact, do call privacy. And I just simply gave names to very familiar phenomena that in our actual world, the one that we all share, people describe as privacy. Now, you might say, well, maybe people describe as privacy some things that shouldn't be described as privacy. Like, for example, there's a whole philosophical school of thought which says that the right to choose, the right to decide, reproductive liberty is not privacy, it's just liberty. And it's misleading to call freedom from government interference as privacy. Let's use privacy more narrowly to just mean this and this. But that feels artificial to me. It feels artificial to me to say, well, even though millions of people use a concept to talk about something that's important to them, that we should ask them to not talk that way, to use some other concept, because it might be strategically advantageous to all pretend as if we don't have a very broad conception of privacy. I think the reality is that in the English language, which we all speak, the word privacy can be aptly used to describe states of affairs and values that relate to all of these kinds of things. And so my goal is not to try to pretend that somehow if we could only all agree upon a narrow concept, that we could all then end all this debate, because I don't think it's that way at all. And in fact, I think that some ways, by emphasizing some of the things that all of these concerns have in common, like maybe the Europeans would say it's all about dignity, or it's all about freedom. Maybe it's what the Americans might say. Maybe there are some underlying values that link together our worries about, access to our information by government and by the private sector, access to our comings and goings by government and the private sector, access to our important decisions and interference with our important decisions about our intimacy and our bodies. Who can decide who we hang out with and who knows who we hang out with, and who gets to control the interests we have in even commercialization of our voices, our faces, our likenesses. Who can decide what we get to read, or who knows what we read, what books we check out of the library, et cetera. Maybe there's something that links all this together, and it may just be some very, very broad but important values, right, that I think we shouldn't be overlooking. Now, strategically, I'm a lawyer, so I do strategy is great, So if I thought that it would help the debate about, say, abortion rights, if we just used privacy in a narrower way to say, all we're talking about with abortion is freedom from governmental interference with decisions about terminating a pregnancy. If I thought that move would just open the floodgates to a much better world, I would go there. But what seems to me to be more likely is that when you start to prescribe for reasons of analytic clarity how people just use the language of privacy, that all you get is just a different set of debates, right? About, why can't we, why should we, limit ourselves to a particular set of ideas and not to acknowledge. People are trying to say something when they use privacy discourse, right? When a black person says, facial recognition technology, which is sometimes very inaccurate, violates my privacy, they're saying something, whether you think that's a classic or well thought out use of the word or not, isn't it more important to figure out what they're trying to say with that statement as opposed to whether they're using the word privacy perfectly. So I just want to kind of, after years of trying to be a good philosopher and have my own theory about the definition of privacy and blah, 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 I just said, basta, enough. What I really want to focus on is critical definitional facilitation. Let's figure out what people are trying to say using privacy discourse, figure out the justice of what they're trying to say, and go for that, as opposed to let's as philosophers have the most defensible, necessary and sufficient condition meeting definition of privacy imaginable. Let's use all the right paradigm cases to decide. That to me is just garbage because it hasn't gotten us anywhere. It's gotten us, I think, instead in this very bad place, which makes it difficult for me to talk to engineers, for example. Maybe have some engineers in the room, but the scientists, the computer scientists are particularly, I think, driven crazy by all these very technical, narrow definitions of privacy coming out of the academy, which aren't helping them design their software any better, right? So who are we trying to talk to? Who are we trying to communicate with by our definitional work? So again, I hear you, and I think it would be really important to try to always answer those kinds of questions well, and I could maybe do a briefer job of it in the future. But I just don't think that it's going to be about trying to narrow or strategize around narrower definitions to get us where we want to get to. Yeah.
Thank you. There are other questions, I'm sure, but I can't resist jumping in and saying that is so refreshing to hear you say that. And it's one difficulty I sometimes have with philosophers' views of applied ethics, which I don't think it works in the case of information technology. It's not like, okay, let's get this theory straight. Utilitarianism is right. Now let's apply it to some problem out there. We need to start on the ground with what's actually happening and listening to people. So I really like your approach.
Thank you.
A lot.
Thank you.
Since I don't see lots of hands, I see one, so just 1 second. But I'm going to ask you what you think about the criticism that Catherine McKinnon and others have made about Roe, that really it should be about equality and not privacy. Because I think to get at this, to really understand why the right to abortion is essential to the concept of ordered liberty, you've got to have some awareness of gender equality and its importance to women.
Yeah. So I wrote this paper a number of years ago. It was actually part of a series of papers that were commissioned by Jack Balkin at Yale, the Yale Information Society Project. And it was a book called, What Roe versus Wade Should Have Said.
Yeah.
Right? And I think that a lot of people who wrote about what Roe versus Wade should have said argued that we would have been better off if, in the Roe decision, the court had used an equal protection argument instead of a privacy argument. And I've talked to Catherine McKinnon about this point, and I've talked to others about it. Why did we use a privacy argument? So why was the privacy argument used in the 1960s and 70s in connection with reproductive rights? Answer that I got from one activist is that at the time, privacy was the more conservative argument. If you wanted to convince an elderly male judge that women should have a right to use birth control or have sex outside of marriage or have an abortion, appeal to the idea of privacy. You're invading their privacy, the privacy of their bodies, their families, their homes, if you don't allow this protection to exist. And I think that was true. I think that at the time, as opposed to saying women are equal to men, remember the Equal Rights Amendment failed. America was not prepared in the 1960s and 1970s to view women as the equals of men. Remember, the 1960s, there were very, very few women lawyers, doctors, government officials, scientists. We were on the margins of society, largely in caretaking roles. We might have a great career as a nurse or a teacher, but we were not running stuff. We were not running stuff. So in that context, it was seen as more radical to say equality. But I decided to approach this in a somewhat different way, because part of the exercise of writing what Roe versus Wade should have said was to put yourself back in the 1972 time frame and only use arguments and legal precedents that were available to the Supreme Court at that time. And looking at equal protection jurisprudence circa 1972, I'm going to tell you that we would never have gotten the right to abortion using 1970s equal protection jurisprudence. It just simply was not construed broadly enough to protect this novel interest. And basically, also, I believe that if you don't want women to have abortions, it doesn't matter whether you use privacy arguments or equality arguments. There are going to be some of the same constraints, some of the same limitations on what society is prepared to embrace. So I'm not saying right now, and almost nobody is, that if we just go back to equal protection, we can undo Roe versus Wade being undone. It's not going to be that easy. We have to work on the ground towards changing people's attitudes about the relationship between abortion and citizenship, which will involve some equality concerns, will involve some privacy concerns, will involve some harm avoidance concerns. All three, at least.
Thank you. I saw a question over there. Well, yes, start with you. And then there's one from the online audience and one from over here.
You kind of touched on this a little bit, but I second what Professor Bryson said about, I couldn't agree more. And it is refreshing to hear you say that, to hear what people have to say rather than being super nitpicky and specific. But I feel like a key problem with a lot of people in like higher up positions or powerful positions is that they don't actually want to listen to what people have to say, or they have I guess like selfish agendas, or whether that be like financial reasons or other reasons. So my question is, how do we actually get people to listen and understand what people are saying and to create this change or movement?
Thank you. I was educated at Harvard Law School by law professors who were legal realists. They were not idealists, they were realists. It was the beginning of critical legal studies and feminist legal theory and critical race theory, and all these ideas helped to shape the lawyer that I am today. And coming at this from that point of view, of course, the politics of our discourse, the politics of our rhetoric and of our political processes it's unavoidable, and it's deep. It's politics all the way down, right? Okay, so assuming that's true, when I say that I think that we should shift our attention from prescriptive analytical definition to critical definitional facilitation, who am I talking to? I'm talking to myself. I'm talking to people like me, because if I listen to other people and try to articulate their concerns using a combination of privacy discourse or not, because I have the ability to talk to members of Congress and leaders, corporate leaders, and state government officials, perhaps I can do some of that translation that we're talking about that needs to get done. I'm not saying that every man or woman on the street is someone that will have the ear of Tim Cook or Jeff Bezos or whomever, Elon Musk or President Biden or Senator Gillibrand. But the whole point of being a progressive lawyer, the whole point of being a law professor, the whole point of being a scholar, the whole point of being an activist is to take one's voice on behalf of the public and amplify it. So I do that in many different ways. So back in the day, back in the 90s, I was actually the chairman of the board of Planned Parenthood, Metropolitan Washington. And in that role, as being on the board of one of the major Planned Parenthood divisions in the country, I was able to amplify the voice of the voiceless, right? Today, I'm on the board of something called the Electronic Privacy Information Center based in Washington, D.C. I was just the board chair. I'm also on the board of something called the Future of Privacy Forum. I use these platforms to amplify the voices that I'm hearing. I'm on the board of the National Constitution Center in Philadelphia. I can use that platform to amplify the voices of people that I hear who are saying things important, using privacy discourse, using equality discourse, using the discourses of harm avoidance. I can amplify their concerns. So I think we need to all find ways through our various responsibilities and roles to amplify the voices that we can hear, to give people who don't have access to the corners of power access. I'll just mention, if I could, just mention two examples of you've heard me, Susan's heard me so many times, she's like, I'm tired of hearing that. But just a couple of examples. So I'm very proud of the fact that I was cited in the Indian Supreme Court's landmark decision in Puttaswamy versus Union of India in 2018. This Supreme Court of India case found for the first time that the people of India have a right to privacy in their constitution, and they cited my work, right? So, wow, I mean, it made me feel great that I'm, struggling away in the trenches in the United States, never been to India, never set foot in India, but yet the kind of arguments that I make on behalf of dignity and privacy found their way into the Indian Supreme Court's interpretation of their language of dignity in their constitution that gave their people a right to privacy that was then used in a case involving a biometric national ID card to limit what the government could do with the data that was collected through this national ID card system. Very proud of that. Another example from my experience that I'm very proud of. So when the Europeans enacted their General Data Protective Initiative in I think it was also 2018 as it happened, went into effect early that year. That fall, I was invited by the European Union Data Protection Authority to come to Brussels and to give a little speech about the ethics in digital life. I said, don't you want me to talk about privacy law? No, talk about ethics, because we have a law now. Now we need somebody to sort of put the oomph, to sort of remind us of the values that are at stake behind our data protection regime. And there I was, in the European hemicycle in Brussels, and there's like Tom Cook, the CEO of Apple, speaks just before me, and Mark Zuckerberg is like speaking after me, and Tim Berners-Lee, the guy who invented the internet, he's like speaking. So we're on this amazing panel. Actually, Mark Zuckerberg, who's there by video, he couldn't come in person, but the rest of us were there in person, and it made me feel like, okay, humble me, this little black girl from Georgia, have the ability to grow up to be somebody who can speak to the corridors of power, right? And to advance my ethical values that I hope I share with so many other people. So that's the long answer to your question, which is a good question, right? Which is, how do people get heard? Unfortunately, they don't. Sometimes they do get heard through direct action, right? That's what social movements are all about. Is 1 million people assembling on the U.S. Mall in Washington, D.C. and making their voices heard, right? But even without that kind of mass movement, there are ways in which we elites can help to amplify the voice of those people who are less able than we to access the corridors of power.
That is a wonderful message to the students in the room. I think virtually all of whom are taking philosophy courses this summer. You can do philosophy and change the world. It's not this esoteric, abstract discipline. Although there may be some limits to what you can do. And this question from Reg, an online audience member, Reg, class of 1963, may test you. How would you fix the current Supreme Court?
How would I fix the current Supreme Court? Well, there are some people who think that the current Supreme Court needs to be fixed by court packing, by adding more seats to the court to water down the current majority and turn it into a minority. And I'm not advocating that we do that at this moment, but it is a possibility that a administration is frustrated with the court if it seems to be moving in the wrong direction to go in. I come from a military family background. I'm in some ways conservative by training. I mean, I do like to try to work within institutions to the extent possible, right? And so I like to think that just as we once had Dred Scott holding that, that blacks, whether enslaved or free, are not citizens of the United States, and we changed that. We once had Plessy versus Ferguson saying, oh yeah, states can legitimately segregate the public railroads, right? That used to be us, and now we move beyond that. And we got there through a slow process, but we got beyond that. Think about this whole Roe thing, is that it feels like we're slipping backwards. Like most of my life, I feel like we're marching, forward, progress. And then I'm like, okay. But think about the people who were around, at the moment of Plessy or the moment of Dred Scott, who were surprised that, you mean even a free black person isn't a citizen of the United States? These were like surprises. So we can work within institutions to affect change. And lawyers, we bring lawsuits, we strategize about what lawsuits to bring, the timing of those lawsuits, et cetera. We encourage mass protests and peaceful protests to get our voices heard and amplified. All of those mechanisms are ways to, in some sense, change the court, right? Because if the society as a whole can change, and we have people in power in the state legislatures and in the Congress who have a different point of view, the Supreme Court's decisions will become different once again, right? So there's that. So court packing, working very hard on the state level to change state lawmakers, because all that disarray on the state level could be addressed if we had different people being elected into office who saw the world differently, and maybe who were motivated for a more consistent and more progressive and more empowering approach to reproductive rights. And then electing more people to Congress who have the ability to focus on data protection and on reproductive rights to create a foundation of rights for women to rely upon consistently. So I think all of those strategies are strategies that are worth talking about. But I don't have like a formula for fixing the current Supreme Court, right? It's a life-tenured institution. So I'm thinking, isn't this the perfect moment to question whether or not we should have life-tenure federal judges, or judges on the Supreme Court? Maybe if they had shorter terms. In many countries, the Supreme Court justices don't have a life tenure. They have to, it's a short, 20 years. We could have a term limit. But then term limits have their own problems. The court might be even more political if it were subject to term limits. So it's not so clear that that's the solution either. We're in a real pickle, class of 63. We're in a real pickle here. And I can't fix the court, but I welcome ideas about fixing the court that I can myself chew on, and I hope that as time progresses, we'll all come up with some useful strategies for quote unquote fixing the court, which might mean focusing less on the court and on other institutions that support and feed the court, right? I think that's what I mean.
Thank you for that. We need to wrap up in about 4 more minutes, but we have time for one quick question and then give you a minute to have any last remarks for us.
Could you tell us what law schools from here on are going to be teaching their students about substantive due process and fundamental values following the decision by Alito and now 6 conservative justices on the court? Are students going to be taught something very different about substantive due process and fundamental values?
There are over 200 law schools in the United States, and there's no single authority which tells those law schools how they have to insist that they're extremely broad-minded and diverse faculties think about and teach substantive due process. I can imagine that some people like me will continue to teach substantive due process and teach the recent cases which challenge certain particular conceptions of substantive due process, right? There may be some professors who say it's over with, no more substantive due process. it's gone forever. I'm not sure that it's gone forever. We don't know yet. That's the thing. We don't know yet what the implications of Dobbs actually are for the entirety of what is sometimes called substantive due process jurisprudence. Substantive due process jurisprudence just means that you use the language of liberty in the 14th Amendment as a broad concept that enfolds ideas about particular kinds of freedoms, like freedom to travel, or freedom to have a family, or freedom to have sex outside of marriage, or freedom to use birth control, or freedom to decide when you die, right to die. All these ideas are read into the language of liberty. And whenever you start reading into language that's very broad, like dignity or freedom or liberty, then inevitably people's their own values start to emerge, right? Because one man's liberty is another man's not so liberty, right? So I hope that what happens now is that we can be extremely honest with our students about the nature of constitutional jurisprudence. That it's not about taking some words and saying what those words have to mean, what they meant in 1800, or what they meant in 1789, or what they mean tomorrow or today. What we need to do is to teach our students that the Constitution is always, 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 always being interpreted. And it's being interpreted through plain meaning jurisprudence interprets the Constitution. Substantive due process interprets the Constitution. Liberal legalism interprets the Constitution. Critical race theory interprets the Constitution. Everybody is interpreting the Constitution, and we don't agree as to how the Constitution ought to be interpreted. We all agree that at some point there's got to be some values there, but we don't always agree about how those values come in legitimately into the conversation. But let's just be honest with our students about the nature of the beast. Let's not pretend that it's easier or less political than it actually is, because it's hard and it's very political. I'll end there.
That's all. Thank you, Professor Allen.
Thank you. Thank you.